Good morning to all of you. I'll check first with Miss Ward. Miss Ward, there's been a default ordered in this particular matter. Are you contesting or disputing anything?
Yes, actually, I would like to know how there was a default other than the fact that I didn't contest the original filings.
Okay. Well, that's how a default got entered. It says on the summons that you have 21 days to file an answer to the complaint, which you didn't do. So that's why you were defaulted. Anything else, ma'am?
Yes, I am contesting the ex parte order. Like, I would like that lifted. And the parenting plan, 42 days out of the year, that's a little, that's not okay. Especially since I've been a mom since I was 17 and my kids, they've never been without me. So this is the longest 6 months ever.
Ms. Reed, what do you have to add in here?
Well, we have not received any pleadings from Ms. Ward. There has not been an answer filed. The ex parte was not contested or objected to, and so we're requesting entry of the default today, and we do believe the parenting time plan, because Ms. Ward left the state, leaving her children in Michigan with my client, we do believe it is appropriate considering the children's age and they are in school.
Okay. She states that it's 42 days. Is there a reason we deviated from the normal?
Well, right now she's in Colorado, I do believe.
Oh, okay.
And so she's out of state quite a ways. And in the judgment, we did give overnights and holidays, which is pretty standard. Let me look. It's spring break, winter break, summer break. So it's pretty typical for the out-of-state parenting time schedule, except for in summer vacation, it's 4 weeks of summer break due to the children's school schedule.
Okay.
My kids are homeschooled, Your Honor, and they have been homeschooled since 2020, and I pay for that.
Okay. Well, ma'am, what you have to do is you're going to have to take some action, and you're going to either have to file a motion to set aside the default, or you're going to have to file a motion for additional parenting time, but that's up to you. You can file that at any time, at least the motion for the change in the parenting time. As to the other, what the court will do is I am going to take proofs today. I'm going to hold up signing everything for a week. If you don't file anything within a week, the court will go ahead and enter everything. So it's up to you on what you want to do, ma'am. So.
Okay. Do you recall filing a complaint for divorce?
I do.
At the time the complaint was filed, were the allegations in the complaint true?
Yes.
Are those allegations still true today?
Yes.
When you filed the complaint, had you been a resident of Michigan for at least 10 days?
Yes.
I'm sorry, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And then the Calhoun County for at least 10 days?
Yes.
Were the allegations true that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood they can be repaired?
Yes.
And that means that there's under no circumstances can you and Miss Ward live together as a married couple?
Correct.
To the best of your knowledge, is Miss Ward pregnant?
No.
Do you share minor children?
What's that?
Do you share minor children with Miss Ward?
Yes.
And have you had an opportunity to review the default judgment of divorce and its terms?
Yes.
In regards to the children, do you believe the parenting time schedule and the custody provisions are in their best interest?
I do.
Do you believe the property division is fair and equitable in its terms?
Yes.
Do you have any questions for me?
I do not.
Do you have any questions for the court?
The kids are homeschooled now, but I don't plan on keeping them homeschooled for much longer.
Okay. If it pleases the court.
Okay. Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending anything that the defendant may file in the next week. So if I don't get anything filed, I'll enter those orders next week at this time. And that will conclude your case. Again, once we get those orders entered, so you're free to go. Have a good day.
Thank you.
Good
Thank
morning to everyone.
Good morning.
Court will note the appearance of Ms. Reed on behalf of the plaintiff and Mr. Schaefer on behalf of defendant. This matter is before the court on the defendant's motion to change custody of parenting time. And Ms. Reed has filed a answer disputing your allegations, Mr. Schaefer. Anything else to add?
Well, no, I've received the answer. I guess the only thing that I would point out is that much of that which is alleged is admitted. And we've got a situation where we got a 14-year-old child who is doing well in school and sports, who for whatever reason is put under, I submit, a punishment for her basic needs based on whatever program they've got in that house. And as a result of that, she is suffering emotionally and is struggling to keep up with her schedule. To have sanctions for things such as food, light, take the light bulbs away, which is admitted, putting eviction on your room and your furniture because allegedly not following the rules. And we are submitting that the food that is available is different because of punishment. I think that needs to be changed. It's having an effect on the child. And this is the only way that we could bring that to the court's attention. We submit, in spite of the rebuttal on the answer, that efforts have been made to discuss that with the plaintiff to no avail. So I think if there is a dispute, I think there needs to be a hearing. That's our position, Ron.
Okay, thank you. Ms. Reed, anything else other than your answer?
We rely on our answer, Your Honor. The allegations are not true. There is a chore system in place with an allowance system that goes along with it. The child has not been denied any basic needs. She did not clean the main bathroom, so she doesn't get to use the main bathroom. There are 2 other bathrooms that are available. Food has never been used as a punishment. There was a 2-hour lights out period on one occasion as part of the punishment where she probably had to go to bed early, and to make sure she went to bed earlier to follow through with the punishment, yes, the light bulbs were removed for a 2-hour period. That is not unreasonable. She could have done her homework anywhere else in the house. These are normal punishments to go along with consequences of not doing her assigned chores. We submitted the chores list to the court attached to our response. None of the chores are that unusual or ordinary. She has to clean up after dinner. She has to help cook dinners and meals. She has to clean the bathroom. She has to help essentially keep up the house and with the rest of the family. This is not singled out to her specifically. And she has to help clean the bathrooms, keep her room tidy, and help around the house. The plaintiff is teaching her responsibility in that he's teaching her how taxes work, how expenses work, and that goes into the plan of the allowance tied into the chores of you do your chores, you get allowance, you get fund money. You also are taught savings, you're taught expenses, and we do not believe this is like an abuse and neglect situation as the defendant's motion reads. So we're requesting that the motion be denied and that parenting time be switched to alternating weeks as the child is now a teenager, and the 2 to 3 alternating schedule that the parties are doing is causing some issues with taking extended vacations, as well as when there is ever a extended weekend during someone's parenting time according to the school schedule. We are also requesting attorney's fees.
Okay, thank you. Well, what the clerk's going to do is, as I read the petition, obviously there's a sufficient proper cause and change in circumstances alleged in the petition to meet the ADVARCA threshold for an evidentiary hearing. I know that is disputed, but that's why we're going to have an evidentiary hearing to make a determination in this matter. The court will reserve on attorney fees pending the outcome of that evidentiary hearing. We will be in contact with both your offices to find out when we could get those arranged, and then we will proceed. Anything else, Mr. Schaefer?
Does the court wish an order based on the court's finding?
Yeah, well, if you would, just state that the court will set the matter for evidentiary hearing and will reserve on attorney fees.
All right, I will prepare that and submit it, Your Honor. Thank you.
Ms. Reed, anything else?
No, Your Honor.
Okay, thank you. Court will note the appearance of Ms. Storm on behalf of the plaintiff, Ms. Ives on behalf of defendant. This matter is before the court on the plaintiff's motion to preserve status quo. Ms. Storm, you can proceed.
Thank you, Your Honor. I believe our motion speaks for itself, but essentially what we have is issues regarding the minor child in kindergarten. And as the court is aware, kindergarten is not compulsory attendance in Michigan until school is not compulsory until first grade. However, these parties agree that the child is ready for kindergarten and should be enrolled. They don't have an agreement at this time as to where the child should be enrolled. So the child goes back and forth depending on what parenting time schedule is at that time. Additionally, there are issues regarding my client used to be able to pick the minor child up after school and would provide care for him and watch him for mother until mother was done working. That's no longer happening, which my client would desire to resume. We understand that essentially we cannot do a real ruling today based on the fact that we have conflicting sides and we have a stack of evidence here that is based solely on the response that mother had to our ex parte. So we do have mediation scheduled for next week with mediator John Brundage on the 23rd. So there is hope that we will be able to resolve it then. However, we would be requesting an evidentiary hearing to try to resolve these issues should mediation be unsuccessful.
Okay, thank you. Ms. Ives?
Thank you, Your Honor. If the court were to make a ruling today, we would ask that the court rule in favor that the child stay in Dudley Elementary. There is a contentious piece in this matter. The history is that the child was attending preschool at Bright Lights Learning Education Center. And then in June, the plaintiff father on his days, on Thursday and Friday, signed the child up for the Montessori daycare. Unbeknownst to my client, his intention was to enroll that child in kindergarten there. My client was very opposed to the private school for a number of reasons and had indicated her intention to enroll the child in Dudley Elementary, which is not far from both of their homes. That school being a STEM cell school and knowing that the child gravitates to math and science. My client did enroll the child in Dudley. The child does currently go to school at Dudley on Monday, Tuesdays, Wednesdays. And then on alternating weeks when the child is with her on Wednesday night, on Thursday mornings. And now since fall, the child also goes to Montessori school on Thursdays, alternating weeks, and then every Friday when the child is in dad's care. We believe that that's really inconsistent for the child. We believe right now, pending mediation, the court should make a ruling that the child be maintained at Dudley Elementary. Ultimately, this is a contentious matter, and if the court decides not to make a ruling today, an evidentiary hearing would need to be held. We do have mediation scheduled next week with hopes that we can resolve these matters. The child is in fact in kindergarten right now, and I think both of the parties do agree that the child is ready for kindergarten. Thank you.
Okay, thank you. Well, what the court's going to do is, I do note in the reviewing the answer does admit that the parenting schedule of paragraph 5 of the plaintiff's petition is correct and accurate. So the court will order that parenting time continue as per paragraph 5 of the petition or motion in this particular matter. The court's not going to intercede at this point as it relates to schooling. We'll address that through an evidentiary hearing if we have to. So we will set an evidentiary hearing and keep us posted if you're able to get resolution through mediation, and then we can take that off, but we will set it for an evidentiary hearing. And Ms. Storm, you can prepare the order as it relates to that parenting time as per your petition.
Thank you, Your Honor. And just to clarify, does that include the practice where my client would pick the child up after school and provide care for the child until mom finishes working?
They've admitted to paragraph 5. I think that's what you have in paragraph 5. And as a result, the court is going to continue that, I guess you say, schedule that the parties have been utilizing as agreed to in the answer.
Thank you, Your Honor.
I think that just to clarify though, Your Honor, the child is in an after school program at Dudley Elementary where he does work on his math numbers. And so we think that that's beneficial for the child to maintain in that program until further order of the court.
Well, I don't know how beneficial it is, and I don't know if something's going to be resolved through mediation or evidentiary hearing. So I don't think that's going to, again, create any sorts of issues in that short period of time. I'm simply going to continue what's in paragraph 5 at the current time. Okay.
Okay.
Thank you.
At 9:29 a.m.
Thank you, Your Honor.
Swim the, yeah,
Have a good
swim the
day.
interpreter in, yeah.
Do you solemnly swear or affirm that you will truly and accurately interpret these proceedings between the court, counsel, parties, and witnesses in the matter now pending to the best of your ability?
I do.
Court will note the appearance of Ms. Moss on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary property division, custody, parenting time, and support.
Good morning, Your Honor. I'm here supervising Elizabeth Sachs, who is a graduate of law school and awaiting bar results. We submitted a letter to the court several months ago requesting that she be allowed to practice under supervision, and I will be letting her handle this hearing.
Okay, I'm sorry, I didn't catch your name, so give that to me again.
Your Honor, my name is Elizabeth Sachs.
Sachs?
Yes, sir. SACHS.
Okay, thank you. Go ahead.
Thank you, Your Honor. This motion pursuant to 3.207C is brought today on behalf of plaintiff. It's my understanding that currently the parties are in agreement as to the terms of the motion. Confirm that.
Well, let me inquire of Mr. Fabian. Mr. Fabian, are you in fact in agreement with the motion?
Yes.
Okay, that makes it very simple then, Ms. Sachs. If he's in agreement, the court will grant your requested relief. Do you have anything else, Ms. Sachs?
Not at this time, Your Honor. Thank you.
Okay.
¿Algo más? No, su señoría. Gracias.
Mr. Fabian, is there anything else you have to add?
No, es todo.
No, that's all.
Okay. Thank you all then. The court will conclude this matter at 9:32 a.m. You're excused and have a wonderful day.
Pueden irse y tienen un día maravilloso. You too, Your Honor.
Good morning, Sachs. So you can submit the order under. This
Morning.
matter is before the court on the plaintiff's objection to the referee recommendation. Ms. Yarborough, you attached substantial amount of material to your objection, but I will state under the applicable court rule, it's MCR 3.215 parens E parens 4 requires that an objection must be clear and concise statement of the specific findings or application of the law to which you object. And if there are any inaccuracies, you have to state with specificity the inaccuracy or omission. And after reading your objection, quite frankly, I have no idea what you're objecting to.
Did you get the transcripts? Were you able to review those?
I was not notified that those came in until this morning. I have tons of motions scheduled, so I wasn't able to review the transcripts. But again, I'm asking you you just can't object because you don't like the results of the referee recommendation. You have to state what factual or legal error that the referee made.
Yeah, so I just am objecting to the fact that Ryan doesn't have an established relationship with my son yet. And I just think that overnights are premature. I would compromise to day visits supervised with Family Children's Services so that their relationship can be documented. And then I would be willing to review in 3 months.
Okay. Mr. Van Beck, what's your response?
No, I don't agree. I think supervised visits with my mom is fine. She trusts my mom having him, so I don't see the problem with supervised visits at my mom's house.
Okay.
I think.
Okay. And I don't know specifically what the referee is that in the referee recommendation, Mr. Van Beck?
Yes, sir.
Okay. Well, what's the problem then, Ms. Yarborough?
I just don't feel that his mom, I want it to be a third party impartial person to supervise these visits.
Okay.
I'd like to know, I'd like to have it documented how their relationship is building and growing.
Okay. Well, unfortunately, there may be a lot of things that you want, but in this particular matter, the referee has heard the evidence and made a decision based upon hearing that evidence. You have not, in fact, stated with any specificity, any factual or legal error that the referee made. As a result, the court simply can't set aside the referee order just because that's what you want without, again, complying with the court rules. So based upon that, what the court is going to do is the court is going to deny your objection at this particular time. So that order will remain in place. And the court will end this matter at 10:27 a.m. You're free to go. Have a good day.
Can I say one more thing, Judge?
You You can if you
I'm
want,
sorry.
but I denied her objection, so.
Okay, just one thing we can't agree on is pickup and drop off. There's nothing about pickup and drop off in the order.
Well, it states times, doesn't it, in the
It
order?
states times, but nothing about picking them up or who drops off or picks them up, and we can't agree on that.
Okay, and are you both residing locally?
Yes.
Yes.
Well, if you're residing locally, then the party that is exercising parenting time is the one to pick up and drop off.
Okay. Okay.
That's standard procedure unless it's stated otherwise in the order.
Okay, thank you.
Okay, thank you. Good morning to both of you. This
Good morning.
matter is before the court on the defendant's motion for custody. Ms. Hall, I note you've stated in your motion what you want. However, the court will note that there was a judgment of divorce entered just weeks ago on September 27, 2023. You have to show a factual or legal basis for modifying that judgment since the entry of the judgment. So what is it? What is your basis for modification or changing that custody?
So, Your Honor, back when I accidentally missed a court date because I misplaced the court paperwork. So that's totally my fault. So I wasn't able to give my side of why I should have our kids.
Okay. Let me tell you how this works. I don't want to cut you off, but you're going to get into a lot. What happens when you are modifying custody? The law states that you can only go back to the date of the last order. So you would have to establish a basis for modification from the September 27, 2023 judgment through the current date. You can't go back and say something happened 6 months ago, a year ago, or whatever, because that order resolved and, if you would, consumed all of those particular issues at that time.
Okay, so I have to, I guess I don't understand. There's no legal reason she can't be with me, so I just don't know what else I can do because she's supposed to be living with me. Dylan and I discussed before we even got divorced that's
Okay.
how we wanted.
Ma'am, none of that matters. The judgment.
I know,
of divorce,
I understand.
okay, so it's from the date of the judgment of divorce forward. What is the basis for modification of that?
Dylan lied on the paperwork and said that she was in school and she wasn't over there. She was enrolled in school over in Battle Creek where I live with me.
Okay.
And he also lied about not having a job, and that's why my child support is so high. And also because he claims that she's in daycare when I honestly don't know if she is or not. Last I knew, she was getting babysat by his sister-in-law because she just had a baby, so they're staying home. So I'm paying $300 a month for childcare that I don't think that she's going to.
Okay. What you can do is you can file a motion for modification of the judgment of divorce, set forth your factual basis. For instance, if it says, if you're supposed to pay childcare and there's no childcare, you can set forth that basis that he's not incurring any childcare and you're being charged childcare. So it'd be anything that would be again, a factual or legal basis for modification of the judgment.
Right. And that's what I don't know. I'm supposed to get proof of that and show you. I don't.
You have to have that because if you set forth your factual and legal basis, he said, okay, he's not incurring any childcare. Well, his answer to the motion would be, yes, I am. And here's the person, he gets something.
He never showed proof of any of that.
Well, that's because you didn't contest the judgment at that time. And as a result, he doesn't have to he doesn't establish and provide proof when there's no objection to it.
He's lying about everything now. He's had a job the entire time and he's claiming.
You can always bring that up in your motion to modify child support as well.
I did. Isn't this what I filled out? I'm confused on what I filled out because that's what I went down to a friend of the court and I said, this is what's going on. Can you look into my case? And this is what they handed me for the paperwork that I needed to do.
Okay. Your motion is a motion for custody. Okay.
Okay.
That's what you filed. And so that's what we're addressing. Hold on. Yeah, I'm looking at your motion. I just brought it up. It says motion regarding custody. So that's what's before the court. If you want to address other issues, you'll have to file a motion and provide in your motion that these are the items that you're requesting, the factual basis or legal basis why, and then include what they call an addendum clause, which is your prayer for relief, stating what you want. The only thing I have is a motion for custody. So if you file the appropriate and proper pleadings, and the court will address those at those times, because you have to give the other side notice as to what they're going to have to defend. And if you file a motion for custody, but then you're talking about parenting time and you're talking about child support and all of that, it doesn't provide them with notice of what you're requesting.
Well, my request is that she comes and lives with me, so that it'll figure child support out.
I understand that. And you've not set forth a basis that the court can look at to make a determination from the September 27th, 2000.
Because I want her to. That's why. She should have never been taken from me in the first place. He took her on false accusations.
Okay, just because you want something doesn't mean legally the court can do that. Okay? So what the court is going to do is I am going to deny your motion because you have not set forth a factual or a legal basis for the court to modify the judgment of divorce at this particular time.
My daughter wants to come live with me. Her dad is keeping both of them from me.
Mr. Hall, is there anything else that you have to add in this particular matter?
Yes, I do. Actually, I got the proof of her being in
Sir, hold on. I've denied the motion, so you won the motion. So do you want to argue about winning the motion?
No, if I won, then that's fine.
The rest, if she files another motion addressing all of those other issues she's brought up today, then you have a right to file an answer and again, to refute anything that she states, okay?
Yes, thank you.
Okay, thank you. The court will end this matter at 10:37 a.m. We'll note the appearance of Mr. McGordon in this matter on behalf of the plaintiff. This matter is before the court on the defendant's motion to set aside default. Ms. LeBeau, you can proceed.
I have wrote a good, good morning, Your Honor, first of all. And I have wrote a good reason in my motion to set aside default.
Okay, well, what happened, let me tell you, people will always say, well, I've got these reasons. You have to show proper cause to do that. So it's not just that I have a reason, it's proper cause under the court rules to set aside the default.
So I have to show proof?
You have to establish proper cause as set forth in the court rules for setting it aside.
Well, the only cause I have is what I wrote in the order. Should I state that?
Yes.
Okay, so I was having a mental health issue at the time, Your Honor, and I just wasn't in a mental state to answer anything. I had a mental breakdown. I had to go see a therapist. I wasn't able to do anything.
Okay.
I was severely depressed. I literally had to go to therapy for like weeks straight. And when I finally got right, I decided, let me check on this. And by the time I checked on it, it was in default.
Okay. Court will note that a default was entered back on July 13, 2023. Mr. McGordon, what's your response?
Yes, Your Honor. My first response is, as the court just indicated on the record, the motion to set aside default, given that the default was entered July 13th. If the default is entered July 13th, that motion to set aside default was not filed within 21 days of that entry of that order. And furthermore, as this court has indicated on the record just now, under MCR 3.210B3, the defendant unfortunately has not provided any good cause under that rule to set aside a default motion. She's not even alleged a substantial defect or irregularity in the proceedings, nor has she alleged that there was a reasonable excuse for failure to respond in any of this case. It's just that she had a mental breakdown. Like, it's not like she was hospitalized and missed a proceeding. It's just that she had a mental health crisis and didn't respond in a case filed in April. We're now in October. There's never been an answer filed. I don't believe either of the anything alleged in the letter that was written to the court clears the threshold of good cause under MCR 3.210B3. I know that that rule has been modified, but there was never a meritorious defense offered to this court either in that motion to set aside default. So the plaintiff would ask that the default remain in place, and that if defendant disagrees with that default order, she should need to file a motion to change custody and needs to prove a proper cause or change of circumstances as to why custody should be changed from that default order under Vidvarka, Your Honor.
Okay, thank you. Anything else, Ms. LeBeau?
Well, Your Honor, the only thing I want, like, I don't mind if Miss Hickman has like serenity. The only thing I would want is the parenting time. Like Miss Hickman, Serenity is able to, which is my daughter, is able to go to school out there through high school. I don't mind that. And I just want the parenting time revised. I don't mind paying the child support. I don't mind any of that. I just need the parenting time revised.
Okay.
That's all I
you
need.
always have a right, ma'am. You always have a right to seek a modification of parenting time. And again, what you'll have to do, you'll have to file a motion for modification of parenting time, providing a factual basis for doing so. And then the court will entertain that at that particular time.
Okay. How do I, when it comes to, like if me and Ms. Hickman were able to agree on something with the court, we were able to agree on something and get it documented. Would that be all right with you? Would I be able to submit that in? I believe we can agree on something since Ms. Hickman does want my daughter.
If you can agree upon something, the court can modify the order or judgment based upon that agreement. So that's up to you and up to the two of you. But at this time, the court will deny your motion to set aside the default. The court does not find that there is good cause under the court rule for the granting of the motion.
So what I have to do next is put in a modified parenting time.
You'd have to come to an agreement, or you would have to file another motion, a different motion.
Okay. Do I contact her lawyer or do I contact Ms. Hickman?
That's up to you.
Because I don't have any of I didn't even know when I had called to, do the certification mail, there wasn't a lawyer on present. So I don't know his information to contact him.
His information would be on the pleadings in the court file. So.
Okay. So I would just have to call the clerk's office to get it.
All the clerks get that information, and then you can contact Mr. McGordon.
Mr. McGordon, I'll contact you regarding parenting time if that's okay with you.
Mr. McGordon, you can prepare the order denying the motion, submit under 7-day notice of entry. Good morning to all of you. Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the plaintiff's motion to modify parenting time. Ms. Reed.
Thank you, Your Honor. The parties shared two minor children. That would be Jalen, who is 14, and Mia, who is 7. We're continuing to have issues with the defendant failing to exercise his parenting time. He did not exercise his winter break parenting time last year, and he did not exercise summer break parenting time this year. My client did provide the defendant a calendar of Jalen's football practices and events during the summer break, as the judgment requires the parties coordinate defendant's parenting time around that football schedule. He did not contact her after that calendar was provided. He did not exercise parenting time. The children are extremely upset by his lack of attentiveness and participation in their lives. We're continuing to have issues with the defendant consistent in phone calls with the children, and when he does call, he talks to them for maybe 2 to 3 minutes, then demands to talk to my client, where he's verbally and emotionally abusive. He's abusive in emails and text messages. So what we're requesting is, because the relationship between the defendant and the children is so poor, and we've already tried reunification counseling last year when the judgment was entered, that his parenting time be exercised in Michigan, so not to disrupt the children's schedules, and they feel comfortable in Michigan. They can come home at night to mom. And that the children call him directly for these phone calls to stop the verbal and emotional abuse to Yumi. So requesting modification of parenting time, that spring break, half the winter break, and that 2 weeks out of the summer, defendant would come to Michigan and exercise that parenting time. It's my understanding that with Jalen in football, 2 weeks out of the year, 2 weeks out of the summer, rather, he has what are called dead weeks. And during those dead weeks, there are no football events. So he will be available for that parenting time.
Okay, thank you. Ms. Greenlee-Clore, I have reviewed your answer. You can add anything else you'd like to.
Thank you, Your Honor. I just want to reiterate that when we entered this judgment of divorce was entered merely not even a year ago, I believe, or close to it. At that time, it was clear that Mr. Wharton was not available to have his winter parenting time, as he already had plans for that year. That didn't go into the judgment, but that was already well known by the parties. As to the summer parenting time, well, let me backtrack a little bit. Mr. Wharton did have his parenting time in March for spring break. It went very well. The children had a wonderful time. They spent time with Mr. Wharton. They spent time with their grandparents. It went very well. When it came time to exercise summer parenting time, the summer parenting time calendar that Ms. Wharton provided frankly has no time for Mr. Wharton to have parenting time during the summer. She booked the younger minor child for 6 weeks, 6 out of 10 weeks for camp. I'm seeing gymnastic camp, cheerleader camp, all sorts of camps. And then the older minor child appears to have, according to this calendar, football events every single week, except for a couple of weeks. At that point, it pretty much prevents Mr. Wharton from having his parenting time completely due to Ms. Wharton's actions. That put my client into an impossible situation where he could either say, hey, Mia, you can't go to all these camps. You can't go to cheerleader camp. You can't go to gymnastics camp because you have to come out here and spend time with me. Or telling the older minor child, well, hey, yeah, you've got these things scheduled, but now you can't do these. You have to come spend time with me. It's not fair to my client that Ms. Wharton did this to him. He made the very difficult decision that, hey, these things are already set up. The minor children were already excited about them. That, okay, I guess they've got to go to these. These parties' communication is terrible. These parties also never participated in any sort of mediation. I think today what we need to get done is I don't think the appropriate thing is removing my client's parenting time due to Ms. Wharton's actions. I think the appropriate thing would be to go to mediation, have these parties participate in mediation, and work out a way that, first of all, they're going to communicate regarding these children appropriately. And secondly, communicate with how they're going to schedule this parenting time and how Ms. Wharton can maybe work father's parenting time into these children's schedules during the summer. It's more important for these children to have a relationship with their father than to attend cheerleading camp or to attend a football workout. At this point, Ms. Wharton's actions are what has kept these children away. My client has already taken the preliminary measure of booking a vacation for next summer with the minor children. He's already prepaid it. He's already scheduled it because he feels so terrible about not having the time with these kids over this past summer. But at this point, we have to move forward. We've got to figure out how these parents are going to co-parent going forward. These children, especially the younger one, they're very young. They're going to have a lot of more years left to co-parent. And I think sending these parties to mediation to figure this out would be the most appropriate avenue at this point. I don't think limiting my client's parenting time is appropriate. I don't think making my client come to Michigan is appropriate. There are no family members in Michigan. They're all out where Mr. Wharton lives. Additionally, my client had a stroke, and that was pretty much one of the causes for the divorce. My client would need to bring assistance with him to Michigan to exercise that parenting time. And that's also going to create a hardship to exercising that parenting time here in Michigan. So I don't think that that's appropriate at this time either. Again, I'd request that these parties be sent to mediation. Thank you.
Thank you. Ms. Reed, what are your thoughts on mediation?
My client does not wish to participate in mediation. We have discussed mediation prior to this hearing. We discussed mediation before the judgment of divorce was entered, and we don't believe the parties will come to any sort of agreement to resolve these issues. We've tried reunification counseling, and for the court's information, when the judgment of divorce was entered, we were not made aware that Mr. Wharton was not going to be participating in his winter break parenting time at that time. Okay. The judgment of divorce specifically says that the parties are going to work together to accommodate Jalen's practice in football during the summer. And the reason that that's in there is because that is one of the most important things to Jalen. And it is correct that, Mr. Wharton needs to have a relationship with his children, but right now, he doesn't have a relationship with his children because he's not an active parent. He's not actively participating. And we did reunification counseling last year because in 2021, he had seen the kids maybe an hour. And then last year it was reunification counseling, which was very, very rocky. And then now we're missing parenting time. We're missing phone calls. And it's important to have normalcy for these kids and not to take away their fun activities. And this is why we're asking for that weeks that they don't have those activities in the summer, that Mr. Wharton come out to Michigan to participate in parenting time. And once he's actually consistent in his parenting time and can show that he can actively do that, actively call the children, have conversations with the children that are longer than 2 minutes and not verbally abuse my client, then we can talk about maybe having the kids go to Virginia again.
Okay. Well, what the court's going to do is order at least that there was the issue addressed as it relates to phone calls. The court will allow the defendant to contact the children directly or that they can contact him. As a result, the plaintiff will be out of the mix on those particular phone calls. In the answer, and as stated, there's a lot of reasons that parenting time was missed. So the court doesn't believe that there's a sufficient amount of time that was missed such that the defendant has to relinquish his parenting time. The court is not going to modify parenting time at this particular time. And the court will order in this matter. Apparently, with the one child, there was issues to rest as it relates to football, and the court would continue. Obviously, that the parties would attempt to facilitate and work that out, but the court is going to order that neither party would arrange other activities for the children during the other person's parenting time. So if, again, I don't want other camps or other activities scheduled at a time that the defendant would be taking the children, because that's, again, it's not appropriate to put him or the children in the middle of arguing about when they can go and when they can't go. I understand the football issues addressed in the judgment, so the court would allow that to continue. But otherwise, you don't schedule, Ms. Wharton, you don't schedule activities on times that would be his time. So, because that again is, again, placing him in an untenable position of having to either take the children and incur their wrath, or vice versa, not take the children and then have, the arguments that he's not exercising his time. So, Ms. Reed, I guess I'll ask that you would prepare the order if it's your motion and submit under 7-day notice of entry.
I have a question regarding the football camps, Your Honor.
Yeah.
It's my understanding that these football camps are scheduled by the school, and there's only that maybe 2-week period that there's not football camps.
That would be very unusual. I'm only hastening back to when I played football in school. We had a 1-week camp in the summer, and that was it. I can't imagine that they're having football camp all summer long. So you're going to need to find out when those are, provide Mr. Wharton with the dates when those might particular be, and then you have to see which ones are mandatory, which ones are not mandatory, etc. But he's entitled to his time in the summer, and he's going to be able to take his time. And hopefully you can arrange around the camp so they don't interfere with his time. He apparently has made arrangements sometime already for next year. Ms. Greenlee Corp, provide Ms. Reed with those dates so that they don't schedule stuff around that particular time and any other time he's going to take, and make sure that that's provided to him so she doesn't schedule anything. Okay?
The issue with the dates that are already scheduled that Mr. Wharton booked this.
Well, you can do that. I don't need to do that in orders. I have other motions that I have to deal with, so I'm not going to sit here and work out a schedule. So,
Attorney Reed, let's try to work together to get the schedule for next summer finalized.
Okay. Thank you, Court. We'll end this matter at 10:10 a.m. Good afternoon We're still in morning. Sorry. Good morning to both of you.
Good morning, Your Honor.
Court will note the appearance of Ms. Anderson on behalf of plaintiff, Ms. Bremer on behalf of the defendant. This matter was noticed for entry, and the order granting receivers application for fees and expenses in this matter, based on initially at least some misinformation from my office, is that you didn't have to notice this, but you did anyway, so that's good. And anything to add, Ms. Anderson?
Your Honor, no, nothing to add.
Okay, Ms. Bremer, anything that you would like to address?
Yes, Your Honor, I am counsel for the receiver, not for the defendants.
Oh, okay, I'm sorry. We had it down for the defendant here on the sheet.
So I am counsel for DWH and Heather Gardner as the individual appointed as receiver. I would like to point out one matter, Your Honor. There is a significant typographical error that Ms. Anderson pointed out for me this morning that would need to be corrected before the court could enter the order.
Okay.
On page 2 of the order, the fees to be awarded to the receiver's counsel is overstated. It is stated correctly in the verbiage, $30,000, but in the numerical representation, it is stated as $430,000.
Well, you just got a raise, I guess.
Yeah, there you go. I'm taking a Christmas vacation. In addition, the total again, properly stated in words, but the numerical representation is inaccurate. So I could correct that, Your Honor, and either resubmit and send to the court hard copies, or I could somehow electronically transmit corrected copies to the court.
Why don't we do this, Ms. Bremer? Why don't you just, what we'll do is I'll let you submit under 7-day notice of entry. Just do it that way. And then we can get it entered quickly without having to have any amendments, modifications, corrections, et cetera. It'll just come through in the corrected order.
I will submit a 7-day notice of the corrected numbers in the order and get it out today, Your Honor.
Okay, thank you very much. Good afternoon to everyone.
Good afternoon.
Good afternoon.
Good afternoon.
Well, enlighten me, Ms. Reed, what's happening and where are we at in the case? And
I mean, Judge, what I can tell you is that I spoke to Margaret Hunter on Friday to give me an update, and she's let me know that there's been essentially no progress in the case at all. You'll remember, Judge, that Mr. Boitnott is to be engaging in his own personal counseling as a part of this reunification counseling. Meredith Katz said that. We got a new counselor, Margaret Hunter, is saying that. And Mr. Boitnott is not engaging in that counseling. He hasn't signed a release. And so she doesn't have the ability to essentially make sure that he's doing his personal part of bringing this child together with him. Mr. Boitnott lost custody, if you remember, Judge, because there was criminal activity, aggravated stalking and serious things that brought to light the safety of this child. And so Ms. Hunter is trying to ensure the child is safe. And she has asked, along with, again, every counselor who's had a chance to take a look at this case, that Mr. Boitnott be in counseling. He's not in counseling. So I would say dismiss the motion, and we're happy to, we're continuing to engage in this process. It's just that he's not taking the steps necessary in order to, essentially begin in earnest this process.
okay, Mr. Fernandez, enlighten me from your standpoint.
Yes, I spoke to Mr. Boitnott earlier today. He has been attending weekly counseling for an hour and a half every Monday. I believe he's gone to 9 or 10 sessions now. So I'm not sure where the miscommunication was. He's seeing a counselor named Mr. Simon. He also said that he reached out to Ms. Hunter directly because Mr. Simon said that he didn't need any additional psychological evaluations.
Well, let's get a report to that effect then, so that we're not just hearsay and going on that.
Yep.
And then have him, if you would, too, have him document what the times are that your client went, so that we don't have those issues either.
And Judge, part of our order calls for a release to be signed that would let Ms. Hunter work with his counselor, and that hasn't been done. And so that's, she's happy to do that. We're just waiting for that.
Okay. Mr. Fernandez, maybe get that done as well, and then hopefully at some point we can get the matter wrapped up if depending on what's happening.
Sounds good.
Anything else, Ms. Reed?
At this point, I don't think so, Judge. Would you like me to prepare any order, or how would you like to? Is there anything you would like me to do?
Yeah, why don't you do that? Is just do an order stating that Mr. Boitnott is going to get a report from his counselor showing, I guess you say, progress and any additional recommendations as it relates to counseling, and that would delineate what sessions there were, et cetera. And also do an order that says that he will sign a release of those records to the plaintiff.
Okay, I will do that.
And then what we'll do is give you some time to get that paperwork, and then we'll reschedule it in for another status conference and see if, do we have to set it for trial at that point or what?
Okay, thank you.
Okay, thank you.
Leslie Paisno for plaintiff.
Have a good afternoon.
Defendant and counsel are not here.
Ms. Paisno, enlighten me, what's happening in your case?
Your Honor, it's my understanding you guys should have received a stipulated order to take proofs. We have resolved custody and parenting time and have a signed agreement or recorded agreement on that, and we have a signed agreement regarding all the property and debts in this matter. So I'm just in the process of preparing the judgment of divorce.
Oh, go ahead, Ms. Paisno, when you're ready.
Thank you. Mark, is it true on October 3rd of 1998, you married Heather Lillywhite?
Yes.
And is it correct you were a resident of the state of Michigan for 180 days in the county of Calhoun, or sorry, St. Joseph County for 10 days, immediately filing your complaint for divorce?
Yes.
And is it correct that during the marriage, you guys had 3 children? Is that correct?
Correct.
And that's Titan, Lauren, and Colton?
Yes.
And to the best of your knowledge, is it true that Heather is currently not pregnant?
Yes.
And as for custody and parenting time, you guys agreed to joint legal and joint physical custody. Is that correct?
Yes.
Okay. With some sort of equal parenting time working with a counselor. Is that correct?
Yes.
And is it correct there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is it true that you and Heather do not love each other as you did at the time you were married?
Yes.
And is it true that if this court were to deny your request for divorce, you would not go back living together as husband and wife? Is that correct?
Correct.
Now, you guys through mediation were able to resolve the issues of property. Do you believe that division is fair and equitable?
Yes.
And you're asking this court, once it's presented with a sign or a written copy of the agreement incorporating all the issues, to sign it and grant you a divorce?
Yes.
I have no further questions, Your Honor.
Thank you. The court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs at this time. Sir, you're not divorced till we actually get all that paperwork and get it signed. It still may take some matter of weeks, but as soon as we get that and we get the front of the court approval, we will get it entered. So best of luck to you, sir. I hope everything works out for you. And free to go. Have a good afternoon.
You too, Your Honor.
Thank you, Your Honor.
Thank you.